right, we'll call the meeting to order. We're running just a few minutes late, but I want to thank the members of the committee for coming in today so we can get back started. Hope everyone had a good week last week. I told people that a week without having to hear rumors about when we adjourn is the most pleasant week I've had since Christmas. And thank all of you for being here today. First of all, I want to thank and welcome Judge Arch McGarity from Henry County Superior Court. Representative Lunsford, I understand he's got a bench warrant with him.
Mr. Chairman, he said he wouldn't serve it until after the meeting.
Good, good. That's very decent of him. Let's go ahead and start with, I think we have, how many senators here? 2. All right. Senator or Chairman Wiles on Senate Bill 139, and he'll be followed by Senator Douglas on Senate Bill 23. Welcome back to where it all started for you.
Thank you, Mr. Chairman, and I notice that Representative Franklin is sitting in my old seat, a well-worn corner that was occupied by former Governor Barnes at one point. It's right next to the law books. I was always the guy that got the books for everybody. That was my job down here. I'm presenting to you today Senate Bill 139, which is a part of a package of bills to start working on the indigent defense system problems. We have, as everyone knows, if you read the press and if you've been to the budget hearings, we've got some substantial issues with indigent defense. And this is one of several bills that the Senate has introduced and passed out that deals with this problem. One of the bills we're working on in the Senate resolution that's passed out that'll come over to y'all is a joint study committee with senators, House members, county commissioners, people in the council, lots of folk, and we're going to try to have a really deep study session this summer and try to come up with a permanent fix to the problem that many of us had a role in causing and many of us didn't, and we're just going to try to get a solution. I don't know that we have one yet, but we do know that some of the problems relate to the budget issue, and that's what Senate Bill 139 deals with. Currently, under House Bill 1EX, the Public Defender Standards Council is a part of the judiciary, and that's how it was put in there. And it's a problem because the judiciary branch, when the budget is submitted to the governor simply passes through the judiciary branch budget to the House. He does not have the kind of oversight that OPB has on every other agency that's part of the executive. So basically we get the packaged request from the judiciary branch, and my understanding is, and I don't want to speak for the judiciary branch, but I believe this to be true, they simply took the request from the Public Defender Standards Council and put it as part of their package because they weren't comfortable passing on this budget, because you realize they're the ones that ultimately could have to review claims of insufficient defense of a criminal case, because they're the kind of would be the reviewer of the budget and also the budgeter. And so I came up with a solution along with several other members, and was to move the Public Defender Standards Council to the executive branch. Then their budget would be prepared by the council, submitted to the OPB through the governor's office, and the governor would give to the House the budget that he recommended for them. And I was surprised when I showed up at the hearing for this bill when the Public Defender Standards Council stood up and said, "We agree. We want to be there. We want to be part of the executive branch. We think it's a better place for us to be." So that's what this bill does. Takes them from the judiciary to the executive branch for purposes of organization.
Chairman Franklin. Let's see if we have any questions from the committee first.
I got a question.
Vice Chairman Mumford.
Senator Wiles, has there been any? Are the district attorneys still under the judicial branch?
They are, and
there's always been some question about what branch they're under.
They are under the judicial branch, and as I explained to someone, I said, if someone wants to bring that bill, I'll help you with it. And I think, quite honestly, they belong probably in the executive branch too. But this doesn't get them over there. But I'll let them speak to that. They did not come to us, at least to the Senate Judiciary Committee, and asked to be moved this year. But I think it's probably a good idea. But this doesn't do this. This just takes this unit and moves it over there.
That's
That's all I got.
Further questions? Sarah, what was the little bill that we passed out of here?
House Bill 586.
586. Okay, thank you. Representative Abdul Salam.
Thank you, Senator, for the bill. I'm just curious to know what I guess the officials in judiciary think about this move.
I'm trying to recall if they testified at the hearing. I don't know that the Judiciary Branch stood up and testified at the Senate Judiciary hearing, nor I don't believe have I heard from them formally. They might be here. But I do know when the public defenders, Mr. Mears actually stood up and said he was for it. That's the only people I know that no one testified in Senate Judiciary against the bill.
Judge McGarity, you wanted to be heard. We'd love to hear from you.
I would just like to state that on behalf of this judiciary, we voted in favor of this change at our executive committee meeting, and thought it was the right place for it.
Does that help you out?
That's great.
Okay. Further questions from members of the committee? We had no one that had signed up. Would you check on House Bill 586 when you go back over to
I will.
my former stomping grounds and find out how that's coming along over there, please?
I'll check on it. We have a judiciary meeting in 50 minutes, so I'll go
Wonderful.
inquire about that bill.
That was another bill that was agreed upon by the public defenders and the county commissioners that came out of the House.
Okay.
Limiting the number of attorneys in capital cases and limiting also what they can be paid.
Okay, and so the committee will know. I also have passed a bill out of the Senate that is in Judiciary Civil over here that deals with that same sort of issue. It simply changed the code section that deals with the ability to use contingent expenses to mean hiring attorneys. And it clarifies an old code section that's been used since the 50s to say no, you can't do that, because we're all trying to get to the same problem. And I'll go look at that one. That might be a better vehicle than mine, but I think mine was Senate Bill 86 if I can recall. But that one's in the other committee that meets in this room. But I'll go look at it today.
Further questions?
That was Senate Bill 86.
I think so.
Further questions? Chairman Franklin, you wanted to be recognized.
I'll move to pass.
We have a motion that Senate Bill 139 be given a due pass recommendation. Is there any discussion on the motion? Any discussion on the motion? Hearing none, all in favor of the motion, please indicate by raising your right hands. All opposed, same indication. Thank you very much, Chairman.
Thank you, Mr. Chairman.
Glad to have you
Really
with us.
appreciate it. I'll get back to you about
86 is seat belts and passenger vehicles.
Okay, wrong number. I apologize.
No, it's not wrong. I'll try to find it for the chairman.
Okay, thank you.
Thank you.
Senator Douglas.
It's Senate Bill 67, Mr. Chairman. I apologize.
Did you get that number?
Yes, sir.
Okay.
Thank you.
Thank you,
I'm
Mr.
sorry.
Chairman.
Did he leave? Would somebody grab him by the coat out there, Senator Wiles?
Senators move fast, Mr. Chairman.
I understand.
We have to.
Who will be handling this for you?
I thought you would do me the honor.
That's what I was afraid you were going to say.
Would you want me to choose another big number?
No, I'm fine. Just check on 586 for
I'm
me.
going to check over right now.
Thank you. Senator Douglas, I'm sorry.
Good afternoon, Mr. Chairman, members of the committee. I appreciate you here in Senate Bill 23 today. This is a relatively simple bill that allows or would supersede any local action in the so-called sanctuary movement, would supersede that so that the court system and the Board of Pardons and Paroles could still consider immigration status when deciding on bail or probation or parole. Section 1 and Section 2 of the bill are pretty well identical, except that Section 1 deals with the court system and Section 2 deals with the Board of Pardons and Paroles. So what I'll do, Mr. Chairman, with your approval, is I'll explain Section 1 here, and then everywhere in Section 2 where I've said court system, you insert pardons and paroles, and you'll have the same thing.
I'm sorry, are you You're not asking us to make a change?
No.
Okay.
No.
Okay. All right, I'm with you now.
Okay, Section 1 of the bill, starting on line 18, you'll see would allow the court system, the judges would be authorized to make an inquiry into whether the person that's being sentenced is in the country lawfully. Line 22, the follow-on to that would be, is that person subject to deportation? And then if you flip over, if the person is subject to deportation, then this part would kick in. The judge would be authorized to consider the best interests of the state in securing the certain and complete execution of the sentence. He would also be authorized to consider the likelihood of the deportation may intervene to frustrate the interests of the state if probation is granted, and where appropriate, be authorized to decline to probate the sentence if he or she feels that's necessary for the defendant to pay their debt to society. It's a relatively simple bill, Mr. Chairman. It just lets the state ensure, helps the state and the local governments ensure that if somebody breaks the law and they're here illegally, that they will be around to pay their debt to society.
What is the sanctuary movement?
The sanctuary movement, Mr. Chairman, is what it's called. A number of large cities around the country have decreed that immigration status will not be considered if a person is arrested or for any other reason. They will not consider that the person is an illegal immigrant. L.A., San Francisco, New York, Chicago are some of the cities that have done that. There are no cities in Georgia at this moment that have done that, including Atlanta. And we would just as soon like to head that off if we possibly can. And this would allow the continued independence of the judiciary to be able to consider that at their discretion.
Did they do this, these cities that you mentioned, did they do this by some official action?
Yes, they've passed ordinances that immigration status will not be considered when dealing with these people.
How does this interact with the federal responsibility? I guess is what I'm trying to say.
This obviously the federal courts, Mr. Chairman, can do what they want to do, and this would specifically pertain to state and municipal court system in Georgia, and I don't want to get off on a lecture on what the federal government is or isn't doing on immigration, but this would pertain obviously just to the state and local systems.
Questions from the committee?
Representative Collins will be carrying this for me in the House, Mr. Chairman.
Questions from the committee? Secretary Beard.
Just at the appropriate time, like motion.
Okay. Let's see if there's any questions.
I believe I sat in front of your committee for 2 hours last time I was here, Mr. Chairman, so this might turn out to be a pleasant experience.
You shouldn't have said that.
I have a bunch of questions.
Representative Lunsford.
Yes, sir. I was going to ask if it's okay, Mr. Chairman. Judge McGarity, I feel like you probably already consider their legal status in your sentencing now, correct?
Well, we are required by not statutory, but case law to inform a defendant who is entering a plea of guilty to a felony and certain misdemeanors that the entry of that plea could result in their status, whatever that status may be, if they're not a legal citizen, being revoked and being deported. And so that's we have to ask that question anyway. Usually it's pretty easy to figure out. They tell me anyway.
The translator's a dead giveaway, isn't it?
The executive council basically took no position on this. We thought it was a policy decision that y'all need to make.
Okay.
That we need to be involved in. But we didn't take a position one way or the other.
Okay, thank you, Judge. Thank you, Mr. Chairman.
I should know the answer to this question, Judge, but I don't, and maybe you can help me. When you have someone who's here illegally and is before your court on, and I've seen that on the plea petition, obviously, how does that trigger further action regarding their status in this country?
If they're sentenced to the Department of Corrections, I believe they're supposed to notify, if they're not a legal citizen, they're supposed to notify the federal government, immigration, of their status. And then when they finish serving their sentence, they're supposed to be deported. I don't have any that I've placed on probation that were not here legally. I just haven't had the opportunity that I felt like it was appropriate.
All right, thank you.
Unfortunately, as Judge McGarity well knows, that just notifying immigration doesn't mean they are going to be deported nowadays.
That is correct. Judge
Yes.
Nations tried that.
Yes, he did.
County, I believe.
Yes, he did.
Representative Abdul Salam.
Thank you, Mr. Chairman. Senator Douglas, what would be the, I guess, cost in savings or loss by having them deported before we house them?
I think that to answer your question, and I don't mean to answer it in a roundabout fashion, but I think the answer to your question is that the judge would have to decide if it was in the best interest of the state that they be deported immediately, or if the crime was such that they really do need to pay their debt by sitting in jail. And again, though, the judge can't deport anybody. The judge can turn somebody over to immigration, and they're going to do what they want with them. And that's why I think this bill is necessary, because oftentimes they are not deported. Probably more times than not, they are not deported. So if they're not going to be deported, then they need to, frankly, I think they need to pay their debt to society and be in jail for the crime that they happen to have committed. So as to the cost, I think that you have to look at the cost of their crime. To me, what did the crime cost? What about the victim? That sort of thing. What did the crime cost rather than what is the punishment going to cost? Because we're required, I think, to punish somebody that commits a crime, whether it be, through however we do that, whatever the legal, the Georgia code calls for, we have to do that. But I think that we probably should concentrate on the cost of the crime rather than the cost of what it's going to, what the punishment's going to be, and think of the victims.
Yes.
Just in terms of reading it, it seemed like it could be a cost-saving measure in terms of the thousands of dollars per bed that the state has to bear the burden.
And I agree with you. And I certainly would not stand in the way of deporting someone if I thought they wouldn't be back the next day. But a lot of these people are back literally within a week or two, and so. I think that's just a decision each judge will have to make in the individual case as to what's best for the state.
Thank you, sir.
Thank you.
Further questions from members of the committee? Further questions from the committee? What's the pleasure of the committee? I'm sorry, you had asked to do that. Secretary Bearden.
Make a motion Senate Bill 23 do pass.
Second.
We have a motion that Senate Bill 23 be given a do pass recommendation. Is there discussion on the motion? Is there discussion? All in favor of the motion, please indicate by raising your right hand. Thank you. Any opposed? Same indication. And you indicated that Representative Collins would
We'll carry the bill. Yes, Mr. Chairman.
Thank you very much for being with us.
Thank you, Mr. Chairman. I appreciate it.
Senator Harp.
Thank you, Mr. Chairman.
Senate Bill 203.
Mr. Chairman, I'll be brief. Senate Bill 203 is your metal recycling bill. This was brought out of a concern from industry, the folks that are involved in home construction, industrial construction, and other types of construction, your EMCs and Georgia Power. And what this bill attempts to do is address the problem that we're having with theft of semi-precious metals. And when I say semi-precious metal, I'm talking about copper, steel, zinc, things of that, brass, things of that sort. Particularly very, very sensitive in the brewing industry, where beer kegs is an example, but also very much so in terms of the electrical industry. These folks are going into homes and not literally in homes, but go to construction sites and they steal stuff. What the bill does is this, is it takes the value of the property before it goes to the salvage. Because what the problem is the district attorneys have brought to the attention that, and evidently some courts have held this, is that they would only prosecute the value of the property of the salvage, because what they do is they take the property and destroy it. and I want to say destroy it, to recover the metal. And then they take the metal and they'll go to a junkyard and they'll try to sell this metal. And the perfect example may be a copper coil out of a $50,000, $60,000, $100,000 air conditioning unit may have a value of $200 or $300, just the copper. And what they do is they take it, destroy the unit, pull the copper out of it, melt the copper down, or render it so that it's somewhat untraceable. And then what they'll do is they'll take it and they'll sell it for the value. And it's not. And what the bill does is it looks at it and says, what you do is you take the value of the property before they did the destruction of the property. The penalties are felony, over $500 value, and again, you're looking at the value of the property before the stuff is ripped out of it. If you'd like some testimony, we have a number of people here who can give you some horror stories. Steve Allen's got a particularly gruesome story where a fellow went into a substation and left his fingers, body parts, and other parts that were fried as he tried to steal the metal out of tried to steal parts of a transformer. And we don't know what happened to him, and Steve says they haven't ever recovered the bits and pieces, but he left some substantial pieces at the Georgia Power site. So it is a pretty horrible process, and it's very dangerous. What we're trying to do is stop these things. There's a forfeiture provision in the bill. The vehicle that is used in to accompany the theft, that provision is in the bill to provide that. That's kind of a summation of it. We have people that are testifying. We have, let me say this, we have the recyclers. They're part of the process. We have the beer industry because of the value of beer kegs, which are a tremendous value, and I had no idea of how valuable these particular things were. And I said one company had a loss of some 50,000 of these things. The electrical industry, both Georgia Power and the EMCs, and then we have the construction industry, where they're having a major. And all of these things have put this together. They're all supportive of the bill. Be happy to answer any questions.
Questions from the committee. Chairman Franklin.
Thank you, Mr. Chairman.
Yes, sir.
Senator, I really like what you're accomplishing with the bill. I think it's doing a great thing, and hopefully will preserve property and have a great result. The concern I have is the forfeiture provision. I can just envision, if I can see it, being a country boy from Alabama, I'm sure there's bound to be other circumstances where this scenario would happen, where a builder on inspection finds out that, let's say, his electrical contractor has put in some substandard wiring. So he hires someone, say he hires me, to go pull that substandard wiring out so he can put the wiring up to spec in. But he wants me to do it at night so as not to be disruptive of the whole construction process. And now here comes law enforcement, and they see me pulling wiring out of a building. Not only do I get arrested, but my truck gets seized. Now, it finds out, a day or two later that, yes, I've got a contract to pull that out. But now, since my truck has been seized, now I've got it because of Georgia's asset forfeiture provisions, I've got to sue my truck to get it back. And while we've got some great stuff, having the value of the property destroyed and whatnot, is it a real burn on you to have that forfeiture in there, or would you object to us trying to get that forfeiture out until we can address the whole forfeiture issue in Georgia, where it's if a person's convicted, I got no problem with taking their car, their tools, whatever, upon conviction as part of the penalty, but just on an arrest, a person losing their asset and having to go to court to get it back when they're either acquitted, exonerated, or in any other way not found to be guilty.
I think it adds to the bill. I think it's helpful to the bill, and I would hope someone would have more good sense than to try to go out and take the wiring out at night on a construction site, or at least he'd have the contract with him, and he'd say, or have a copy of it in the truck, so when the police come up and say, "Sir, I'm here by permission. Mr. Jones, whose property I'm working on right here. Here's his phone number. Call him up right now, and he'll verify that I'm here on a legitimate, lawful purpose doing this."
And you could have law enforcement say, "Yeah, tell it to the judge."
I don't think they would. My experience with law enforcement is that in a scenario like that, they're certainly going to investigate. They're not going to take somebody's property without reasonable. Now, if he can't reach Mr. Jones or something else, I think he might have a problem. But and I wouldn't be out there doing it if I didn't have Mr. Jones standing beside me and say, "Okay, Jones, I'll do it, but you better be right here with me." I hate to say, I really wouldn't hope somebody wouldn't do it at night. I think that kind of raises some questions. I would be very suspicious in a circumstance like that. But I think it does add to the bill. I appreciate your point. I understand your concerns. It's modeled after the drug forfeiture law that we have in existence and use extensively, and then this is identical to that law, and that was where this came from. But I think it does add something to the law, and I respectfully understand your position. I hear you, but disagree. Thank you, sir.
That's the only, or let me ask that another way, Mr. Chairman. Are there other theft offenses for which we do forfeiture of motor vehicles, to your knowledge?
I think, I don't know. I don't know the answer to your question. I would think if, any time that a vehicle is used as a means of a crime, there's a potential for forfeiture. I don't know if Jill?
Any other time I'd have district attorneys hanging out of the ceiling in here.
It's actually modeled after the forfeiture of property used in burglary or armed robbery. That's what this section is actually modeled.
Okay.
And that does take more.
Burglary does?
Burglary and armed robbery.
So that.
Okay. Representative Setzler.
Again, just following this trace of the forfeiture discussion. Is there could you describe to me in a little bit more detail the way the forfeiture process plays out? And that might be a question better addressed to Legislative Council with respect to under what circumstances the vehicle that's seized is then turned back over to the accused or the convicted, if that's considered by the courts, and how that all plays out.
I'll defer to Ms. Travis.
I prefer to defer to a district attorney. Really, I'm not familiar with exactly the process that it goes through. It's written here. I've never done a forfeiture.
If the forfeiture is done like we do the drug forfeitures, then what they do is they seize the property, and usually what happens is they hold it until there's a conviction. But once there's a conviction, then they sell it at public auction.
Now, does this bill contemplate, let's say there's a person that's, and again, as I'd said to you in subcommittee, I support the essence of this bill, which is valuing the stolen materials for their market value as opposed to their scrap value. I guess the question is if there's a $300 or $400 value of market value, a relatively small item that's stolen, again, wouldn't meet the felony threshold, but would be below that, and a $15,000 vehicle, a truck, were seized in the course of that crime, is the process going to be such that a $15,000 truck is going to be sold off for a misdemeanor conviction on a $300 theft? And I don't really understand how that process plays out.
You're going to get, as we enact these laws, I always drop back and look at what my district attorneys do, and I have great faith in the district attorneys. I have dealt with them over the years, and many times when, a small quantity of marijuana, something like that, would be found in an automobile, and almost to a T, they'll look at it and say, okay, this is a misdemeanor, and in a misdemeanor they do not forfeit the automobile. At least my district attorneys do not do that. Now, if it's a felony, if it's a large amount, then they'll certainly go after it.
And I'm just asking you because we as a lawmaking body, that seems to be front and center of what our responsibilities are, is to make rules that speak to that, and not be silent on that. And again, as we talk through felonies versus misdemeanors, forfeiture versus non-forfeiture, what's the appropriate level in which a $15,000, $20,000, $20,000 truck, $5,000 vehicle could be kept and sold, and I just want to understand that so I'm making an informed decision.
I think it's clearly understood if you commit a felony, then you're subject to having forfeiture, total forfeiture. But I think if it's a misdemeanor, I think then it's probably a discretionary call, and I would think, or any of our DAs here, I would think they would probably err on the part of not doing it.
It is a civil proceeding. It's not
Yeah.
a criminal proceeding.
Yeah. The forfeiture is a civil proceeding, is it not? Yes. Yeah.
Mr. Chairman, I just offer to the author or to other members of the committee, I'm still somewhat confused on that process, and I don't want to inadvertently make a call that a $250 theft leads to the sale of a $20,000 vehicle if that's not the public policy intent of the committee. So.
I don't disagree. My thought is that the distinction is misdemeanor and felony. If it's a felony, you have forfeiture. If it's a misdemeanor, you would not.
Chairman Knox.
We had something of the same conversation, discussion, and subsequent about this, and claim to be an expert on the matter, but I think the distinction is that this is when you do a forfeiture, it's a civil action, it's not a criminal action. And while the district attorney can exercise discretion on when they use that forfeiture action, what we're about is, this should be a law of that is a law, not a law of persons, and that's what happens when you leave it to the discretion of individuals, because I think clearly this law will provide you do this crime, this vehicle can be forfeited. Now the problem with it is with most of the forfeiture laws is that because it is a civil action, property can actually be seized, sold, and disposed of whether or not the person was actually convicted of the offense for which they were arrested and for which the property was seized. And you don't really have any recourse once that property's been sold. You're just stuck. I mean, you're without it whether you were guilty or not guilty. To me, that's the biggest problem with forfeiture laws, is that I find it difficult to understand that it's still held to be constitutional to do that. I just think it's an unfair taking of property. Other question I have about this, and Representative Setzer raises this point, I'm not sure in the law whether or not if you seize a $20,000 vehicle and the amount of the property that's stolen that we're trying to make up the market value of is $800, is there any consideration given for that when there's an offset against the amount that would be required to be repaid as restitution as part of the criminal offense? Because if you get a $20,000 vehicle and the state keeps that money and the $800 that should have gone to the people doesn't go to them because the guy that's been convicted, he's in prison, you're not ever going to see that money probably. So it looks like the only one that ends up a winner on that is the state getting more tax money, calling it a forfeiture, but it's tax money nonetheless. I mean, it's a form of taxation. It's just one we do because we got a gun that we can make it and do it with.
Counties get it, don't they?
Counties get it.
Is that right, Ken?
Cities and counties. Representative Lunsford was correct in his answer. Whoever the jurisdiction was that sees it, it could be the state, county, city, or even federal government. If it's a federal proceeding.
In some jurisdictions, they split it.
Do you have a question? Vice Chairman Mumford.
I have a question for Ms. Travis. Does this forfeiture provision only apply to felonies, or does it apply to misdemeanors?
It applies to misdemeanors as well. The definition of crime is on page 3.
Okay, here's the next question. where did you get your answer? Okay. Questions to the committee? Chairman Cooper?
Can this be amended some way so that if there is enough money from the court, what is forfeited and sold, to pay restitution to the person who was harmed in the first place? I mean,
I'm not
if y'all
sure.
tell me it goes to the cities and counties, I mean, it does seem like the first person that ought to be able to receive money would be the person that has been harmed. I don't understand why, I mean, if you sell that $20,000 car and it's $20,000 that goes to the counties and cities, I know our counties and cities need money, and they always do, but it seems like the person who had the $800 loss ought to get the $800 first.
I guess
If the person is convicted, then there's always one of the remedies would be restitution. That the court could enact and adjudicate restitution as a part of the sentence that is adjudicated on the person.
But you already, excuse me.
Sure.
Yeah.
But then, Senator, you've already perhaps taken one of their biggest assets away from them. Maybe their motor vehicle is worth $20,000, which they could make it harder for them to pay the $800 back.
I'd sound skeptical. Most of these people, if they have $20,000 truck, it's the bank has $19,900 on it, and they get it back because they're protected by being a lien holder on it. But I don't know. I don't think we are. I mean, the forfeiture is.
Shaking his head. I don't do
forfeiture. We don't get a whole lot of it. Yeah. DAs get a lot of computers, stuff like that.
Something that you pay cash for. But a car with usually there's a note on it, and the lien holder has security on it. So it's rarely do you get anything on there.
Representative Stacey Abrams.
Concerns about adding forfeiture provisions to this bill, so I have an amendment at the appropriate time.
Let's see if there's further questions and discussions before we get to that point. Any further discussions? Any further questions of the author? Okay, Representative Abrams.
Yes. As I said, I agree completely with the intent of the bill. My concern is the forfeiture provision seems a bit of an overreach to solve the immediate issue. So I would move that on page 2, section 3, we strike the word to and replace it with the word a. In that same line, strike the S from section. So that line would read, said article is further amended by adding a new code section to read as follows. I would then strike section 10-1-358 in its entirety, which would mean starting on line 1 of page 3 through line 24 of page 6.
I'm sorry.
So that striking that in its entirety, and renumber line 25 as line 1 for that page. So again, you would strike, starting on page 3, strike line 1 through line 36. Page 4, strike line 1 through line 37. Page 5, strike line 1 through line 37. Page 6, strike line 1 through line 24, and you'd renumber beginning at line 25.
You renumber it to be code section 10-1-338.
Okay. Sorry. So you'd amend it to be 10-1-358. That would be my amendment.
Okay. Do you understand the amendment?
I do.
Okay. Does everyone understand the Abrams? Well, there's not a second. I'm sorry. Okay, you seconded. We have an amendment that's been moved and seconded. First of all, is everyone clear on the amendment? Any questions about the Abrams amendment? Now, discussion on the Abrams amendment. Secretary Beard.
I understand some of the concerns, and I apologize for being in and out of the room. I don't know if this is brought up or not. But I want to speak briefly in not being in favor of the amendment. There's several things that's got to take place before a vehicle is even seized. Number one, is it even worth the trouble of trying to seize that vehicle, depending on how much it's worth. Secondly, is there a co-owner or lien holder on this, maybe the bank or someone else that has a lien on this vehicle that could prevent it from being seized? Third, the people were caught stealing, and one of the things they do is that, well, they may have been caught stealing, that's what they was charged with. Now it's up to the courts to find out the guilt or not. They may have 1,000 pounds of copper in this vehicle, and that's their primary function, to get that copper to the recycler to get it taken and get the money for that to do probably other crimes. I think we're taking out a lot of the teeth of this bill if we remove this section. The industry that's worked very hard on this, along with the author that's worked very long and hard on this bill, state that they feel like this is a very important piece of this legislation. I would ask that we keep it in here for that purpose. I think it does a good deal for the bill and puts the teeth to the bill also on that. And that's all I got to say, Mr. Chairman. Thank you.
Thank you. Any further questions or comments, discussion on the Abrams amendment? Representative Abrams.
I understand Mr. Bearden's concern. I would say that my concern is the process. This is a civil process that's also part of a criminal process, and basically a person who's convicted would be faced with forfeiture without recourse or without actual conviction. And my concern is that, as Chairman Knox, I think, said it best, this is making law by person as opposed to making a general law. We are depending on the beneficence of a DA to determine that they want to follow the process through and that they're not going to take or not going to overreach, and I'm not comfortable making a law that's dependent on the personalities of the venerable DAs that we have in the state.
Further questions? Further questions? All right. We're going to vote now on the Abrams amendment. If there's no further questions or discussions on the amendment, all in favor of adopting the Abrams amendment, please indicate by raising your right hand. Got it? All opposed? The Abrams amendment has been adopted. Is that correct?
Chairman, I had to refrain from voting because I wasn't here for the discussion, so I apologize.
Chairman Franklin, you wish to be recognized? Okay. Jill, let me ask you, in light of that amendment, do we still need to take up the suggestion you had mentioned?
Yes.
Would you show your handwritten note to Senator Hart, please?
Is this what?
This one's helpful.
The property, this is in Title 16 change, and we can bring over in its original and undamaged condition. If you want to keep that.
That's fine. I don't have a problem with that. Yeah. Yeah, that language is fine. Yeah, that's good language.
I have one other question.
Okay. Vice Chairman.
I'll direct this to either the author or Ms. Travis. On page 6, line 26, section 10.1-359, and maybe somebody from the counties or the municipal associations, this does say that this preempts all rules, regulations, codes, ordinances, and laws adopted. I just am not sure what it is we might be preempting there, and I want to make sure that we know what we're doing.
Well, Mr. Chairman, members of the committee, Kim Kimbrough from the Association of County Commissioners. There is some concern about the initial language as drafted kind of was drawn so broad that we were in fear that perhaps some of our regulations regarding additional noise buffers, sighting, and maybe even, we're always worried about zoning and those sorts of issues. But we thought that we worked with the author to have 3 or 4 words taken out that narrowed the language down such that the only area of law, from the context at least, the only area of law that would be preempted would be our ability to draft criminal ordinances or quasi-criminal ordinances related to the sale or theft of metal. So
Do y'all do that?
I believe we did.
there were a couple of cities that were fairly progressive in this issue that had enacted some additional penalties, and counties were taking it up, particularly Bibb County. But we're comfortable with the state regulating this area as it relates to the sale or theft of regulated metals.
Well, would some of these regulations be impositions on the purchasers, that they're required to maintain logs of the people that they're buying these metals from? And
They did that already.
Yeah.
yeah, but I'm wondering if by saying this, we're revoking any requirement that they have under some county or city ordinance to keep information.
That may very well be possible, but I'm not sure if the new custodians of such records, I mean, they would most likely be
What we're trying to do is create uniformity across the state.
Okay. Well, at any rate, the city or counties they're not standing here jumping up and down worried about this particular provision, is what I'm being told.
We're not.
Okay.
And I don't want to speak for my colleagues from the cities, but we're comfortable.
Go ahead and speak for them. I don't mind.
We have no problem with it.
They're on board.
Y'all are getting along so good this session.
We're behaving.
That's right. I just wanted to make sure that somebody had looked at that.
Further questions? Jill, where would this change now be?
My suggestion would be on page 7.
All right, if y'all will listen up, this is an amendment that was, or a suggested improvement in the form of an amendment brought to us by Legislative Council that I understand meets with the author's approval, but I want everyone to listen up.
If the intent behind this is we want to be sure that the value that we're talking about in the theft is the value in its original and undamaged condition, which is the language that's used on page 2, line 28. I think that on page 7, line 3, after the word property, you should add comma in its original and undamaged condition, so that it takes into account original value.
Chair will offer that in the form of an amendment. Is there any objection? Is there any objection? Hearing none, that amendment will be adopted. Any further questions or discussion on the bill? Representative Setzler? Okay. Chairman Franklin had asked to be recognized, and
Yes.
I'll recognize him for that.
I have one other
I'm
question.
sorry, Vice Chairman Mumford.
For the committee, just one more minute. Senator, I like your bill. One concern I have, if it, from reading that, it seems to imply that it's the value as it exists in, I'm thinking of a coil in an electric box somehow. Does that take into account the fact that the coil's 20 years old and it's not the value? Does it take into account the replacement value of the coil? I mean, you buy a car and wreck it, and you get $2,000, not the $20 you paid for it.
I'm just trying to replicate the language that's already used, so that
This was already in the code,
well, no, if you look at page 2,
right?
28, that's the language that's there. In its original and undamaged condition, that's new language being added. And so my point was, if you're going to use that language, you should probably use it in Title 10 and in Title 16,
Right.
so the argument isn't made, oh, prosecute it be under Title 16 because I can get a lesser punishment.
Did you want to respond to that, Senator?
Our concern is not the new item that is a 20-year-old item.
Mm-hmm.
The 20-year-old item that was $100,000 may be worth $30,000,
Mm-hmm.
but it's still worth $30,000, not
Not the
$200.
$300 it is when it's melted down.
Correct. Yeah.
Okay. All right. Well, I just hope this language is going to cover that without creating confusion.
Further questions? Further discussion? Recognize Chairman Franklin.
Mr. Chairman, I move do pass by substitute as amended.
Okay. Representative Setzler seconds it. We have a motion that Senate Bill 203 be given a due pass recommendation by committee sub as amended. Is there discussion on the motion? Is there discussion? Hearing none, all in favor, please indicate by raising your right hands. Thank you. All opposed? Thank you very much, Senator Hart. I understand Representative Bearden is going to be carrying this.
That is correct, sir. Thank you very much.
That amendment, you still want me to carry that?
I think you might be able to, who knows what might happen. Maybe new life will appear. Stranger things have happened in this place.
We got a lot of time. We got a lot of days left.
We do indeed. Thank you, Mr. Chairman.
Thank you.
Excuse me so I can go do justice to some House bills on the other side.
Senate Bill 24.
I got to go up and check in to return it tomorrow. How long do you think before there will be a vote on this next bill?
5 minutes.
Oh, shit. I'm not going.
I think everything's worked out. Right. Who is working on this bill and promoting it? Who wants to? This bill, Bill, why don't you come around and you want to be joined maybe by Brandon? And
Brandon Sherman.
Okay. 24.
Oh, no. This is a different bill. He's talking about the one for the subcommittee.
We have two subs here, sub 1 and sub 2, and I'm not sure which is which. It's not in here. Oh, okay. Where did these two come from?
One is Jeff's, LC 283686, and LC 292853 was done when it came out of subcommittee. After that,
Okay.
it's the 2877 is the LC.
I may have that. $2878S. You don't have that one.
3287, right? Yeah, you're right.
Jill had suggested basically just some technical changes. This had nothing to do with the merits and the things that y'all had in discussion, but I'm wondering how, because I understand all the groups that are interested in this have an agreement.
Yes, sir. That's right.
But I don't know that is the agreement incorporated into either of the two subs we have.
Sub number 2.
Sub number
the
2.
Agreed upon version.
I'm sorry?
Is the agreed upon version, which is 283686. Yes. Mine has sub number 2 written on the top of it.
Jill, which would be easier? Do you see that one?
I can see this one, yeah, but there are a number of mistakes that are in this bill. Like, for example, there's a defined term, interactive computer service. It's never used within the bill itself. The punishment provisions are not how we normally define punishment provisions. And so there's other things that I did in the front of the bill. And I understand the bill that Mr. Clark's looking at takes out the civil penalties. And the bill that I worked on didn't address the civil penalties.
Probably laid them together.
Probably married them.
Okay. And due to the fact that we were off last week, I failed to, because I didn't know about y'all's agreement.
Yes.
Here's what I want to do. We're going to meet tomorrow with y'all's permission, and I hate to do this to you one more time since we've already had this on for full committee, is I'd like for y'all to get with Jill, and then if you would work with them on what they have agreed to, and then make the technical improvements, and then we'll get that one out of here tomorrow. Can we do that? Okay.
That's fine. We're glad to work with her.
Okay. Do you need this one? You have one?
No, I didn't bring one with me.
Okay. I'm going to let y'all make a copy of that so you'll each have one, and any other parties that are interested, just be sure I get one back. Is that fine? Okay. All right.
Thank you, Chairman.
Yes.
Thank you, Mr. Chairman.
Hold on 1 second.
My subcommittee is meeting immediately after this meeting.
Okay.
So you need to make that announcement so that I'll lose.
All right. Let me make a couple of housekeeping announcements before we start breaking up here. First of all, the Mumford Subcommittee is meeting immediately upon adjournment of this committee, which we're about to adjourn. Secondly, I've chatted with the subcommittee chairs, and in the interest of moving things at a little bit better clip, here's what we're not going to, other than what's already in a subcommittee. We're not going to assign Senate bills anymore to subcommittees. We're going to have probably more frequent full committee meetings, such as tomorrow, and I don't know what time yet. But we're not going to load the calendar up with a bunch of bills. We're going to take our time, go through them, do them well, but they're not going to be going through the process twice, since they've already been through the process over on the other side. So we'll get you out a notice about tomorrow. I don't expect a heavy calendar, but I do want to move some things. And so with that, anything else to come before the committee? Any questions from members of the committee? If not, we will stand adjourned, and we'll see you at a time to be determined tomorrow.